For anyone on the bench of the Nigerian judiciary, this chamber is the ultimate.
Let us all strive to maintain the independence of judiciary, the rule of law,
and the fact that the ministry is responsible for prosecution of cases makes the ministry very visible naturally.
If it is to buy time, you know who is buying time.
Becoming the first woman in the country to discharge the function. To me, Allah wished it that way.
Welcome to the program, The Scale of Justice.
Tune in every Monday at 2:05 p.m. and repeat broadcast comes up every Wednesday at 6:30 a.m. on the network service of the NTA. Keep the date with us.
The coronavirus pandemic has forced a change in almost everything in the world, the way we live and the way we seek our livelihood. As a result, we too have had to respond to these changes. But while these responses in some instances are swift and intuitive, others must be structured and planned. In the area of the law and justice, changes are not allowed just by mere fiat. It must be legalized and legitimized, at the least through legislation. I suppose this is a situation that has been in the mind of the Attorney General of the Federation and Minister of Justice, Abubakar Malami, when he called a conference of Attorneys General of all the 36 states of the Federation and heads of courts across the country and the FCT to work out ways the justice sector can respond to the new trend COVID-19 has caused. The conference, which was held by virtual means, of course, another response to the changing times, is going to form part of our focus on the scale in this edition. Welcome to the program. I am Femi Okeowo. Even before now, reforms have been an integral part of Nigeria's justice system. But more so now, with the coronavirus pandemic changing the mode of various activities. The virtual conference organized by the Federal Ministry of Justice brought together the Attorney General of the Federation, Attorneys General of all the 36 states of the Federation, heads of courts in the country and the FCT, and the Solicitor General of the Federation. Areas of the nation's justice system which the body will tinker with in the light of the influence of COVID-19 include virtual court hearings, decongestion of correctional centers, particularly of awaiting trials, decentralization of correctional services, and implications of various legal and statutory measures on our justice system and their constitutionalism.
The purpose of this virtual meeting is to provide the platform for engagement and articulation of our collective views on the issues arising from COVID-19 pandemic and harmonize our resolutions on the way forward. The advent of COVID-19 and the efforts to manage its spread and reduce the human and economic devastation occasioned by the pandemic has made it imperative to adopt systems that will reduce the physical presence or involvement of persons in the judicial process through the deployment of technology to achieve the same objective for which physical presence was intended. However, there have been arguments as to whether the application of virtual court hearing meets the constitutional requirements of fair hearing. I am of the view that this meeting offers an opportunity for further discussions on the issue and a common position taken. This is without prejudice to the ongoing deliberations in the National Assembly to amend Section 36, subsection 2 and 3 of the Constitution. As stakeholders, we have a duty to ensure that the pandemic is not allowed to grant the administration of justice machinery to a halt. We must continue to forge the needed synergy and collaboration to administer justice in the face of the pandemic and align with global best practice. In order to respond to the challenges posed by the pandemic, the Federal Ministry of Justice is currently improving on its ICT infrastructure to enable the ministry carry out its duties. Towards this end, the ministry has completed the establishment of ICT studios and the deployment of Galaxy backbone dedicated lines that will facilitate the prosecution of criminal cases as well as the defense of civil cases using the virtual platform. As the biggest law chamber in Nigeria, and if not in Africa, the Federal Ministry of Justice must continue to lead the process of innovation in the administration of justice. To complement this effort, the Nigerian Correctional Service is also being engaged on the establishment of studios in the correctional centers to make it possible for evidence of suspects in custody to be taken. This will ensure that the administration of justice is not disrupted. In addition, ICT is being introduced in the receipt and processing of correspondence between ministry and the general public to further minimize the person-to-person contact between officials of the ministry and members of the general public. The NCS is currently working with the Ministry of Interior to finalize the guidelines for managing the centers. In addition, judicial officers are advised to be cautious in granting remand orders except in exceptional circumstances and subject to the guidelines to be put in place by the Ministry of Interior and the Nigerian Correctional Service. Furthermore, we have developed an implementation strategy for the Nigerian Correctional Services Act 2019 through the installation of an ICT-enabled national criminal database to promote effective information management in criminal justice administration, decongestion of correctional centers, and non-custodial measures. In order to put in place enduring measures for effective management of correctional centers for the reformation, rehabilitation, reintegration of the offenders back to the society, the decentralization of correctional service in the country has been proposed. This will allow states to effectively participate through the setting up of their correctional centers to manage offenders who commit state offense, while the federal government will continue to manage offenders who commit federal offenses. These measures, no doubt, will address the problem of congestion in the correctional centers as witnessed presently. This virtual meeting offers the opportunity for my colleagues to share their perspectives on the proposed reforms of correctional services in the country. I also consider it most appropriate to utilize this forum to appraise our state chief law officers on the concerted efforts being made by the federal government to strengthen our judicial and democratic institutions for the benefit of our people. There is no doubt that a stronger and efficient judicial system is quite critical to the attainment of the anti-corruption drive of the current administration and the overall improvement in the administration of justice. In furtherance of the foregoing, the federal government constituted special committees to achieve its cardinal goals as follows. 1. The Committee on Implementation of Directive on Designated Corruption Prosecution Courts was constituted to actualize the directive of the Chief Justice of Nigeria to heads of courts to designate specific courts for the prosecution of all corruption-related cases with the aim of fast-tracking their completion. This will improve both the human and technological capacity of the courts, which will also rub off positively on the emerging trend of conducting virtual hearings. 2. The Committee on the Review of Judicial Salaries and Conditions of Service was constituted principally to ensure that the welfare of our noble judicial officers reflect current realities. The committee observed that compared to other public servants and political office holders, there has been no commensurate increase in the salaries and allowances of judicial officers for over 10 years. The committee's recommendations include a proposal for a structured increase of adjustment in the salaries and allowances, housing, medical needs, and retirement benefits, amongst other welfare provisions for their lordships. While the recommendations are awaiting presidential approval, I urge you as stakeholders to also engage in advocacy to bring this reform to life, since state judiciaries will also greatly benefit from it and indeed take advantage of the approval of the autonomy of the state judiciary to see how the welfare of the judicial officers can further be enhanced.
As part of the interaction, Chief Judge of the FCT High Court, Justice Ishak Bello, gave a perspective into the multifaceted implications of COVID-19 on the future of administration of justice in Nigeria. Justice Kashim Zanna, Chief Judge, Borno State High Court, took participants through the benefits, challenges, pitfalls, and lessons of virtual hearing in the Borno State Judiciary. Professor Akinseye George did an appraisal of the implementation of the remand protocols in the Administration of Criminal Justice Act as concerned the case of awaiting trial inmates.
The Honorable Attorney General is bringing all of the critical stakeholders together, attorneys general and chief judges. And these are the two people who can change, who can solve the problem of overcrowding of the correctional centers with awaiting trial inmates. My paper makes clear that with effective oversight by chief judges, effective oversight by attorneys general, that is the executive and the judiciary. These are the heads of the executive and the head of the judiciary in the states. If there is effective coordination, we can solve the problem of overcrowding of our prisons with our waiting trial population, because our waiting trial population in our prisons damages the integrity of our criminal justice system. It is not consistent with democracy for you or for us as a democratic country to continue to keep people in prison who have not been tried, particularly in this period of COVID-19 pandemic, when there must be social distancing. The opportunity to maintain social distancing is not available in the prisons because the prisons are overcrowded. The space available for each prisoner is so small. So we are proposing that we should adopt thoughts that are outside the box. we should think outside the box. The traditional methods we have used have not worked in the last 30 years, and they are not going to work. What are the traditional methods we have used? Jail delivery by chief judges, setting up special presidential committees, we call them decongestion committees. These things can only scratch the surface. It cannot address the root cause of the problem. Because the presidential committee, for example, will not recommend that people who have been charged with capital offenses, they should be unleashed on the society. That cannot be recommended. You can only release those who are either aged or those who committed minor offenses, and so on and so forth. So what we need to do, therefore, is to repair the broken chain of our criminal justice system. The criminal justice system has 7 principal components. The first component is the public. That's the investigators and informants. Without the support of the public. And what that does is that it provides information to law enforcement agencies. It helps to prevent offenses or offenders. So that's a fundamental approach. Then that connects, that flows with the investigators who are well trained, well supervised. Investigation of cases must be under the oversight of attorneys general, because they are all part of the executive. And that's what the Constitution says. Attorney General is in charge of the criminal justice system from the point of view of the executive. Then that flows to the prosecutors. Even in agencies where you have investigators and prosecutors under the same roof, like under the anti-corruption agencies, it is a tall order to make them to cooperate. But where the head of the institution says, you guys have to work together, then we are moving towards speedy trials. And if investigators and prosecutors are together, you can have day-to-day trial. Before you arraign a suspect, the witnesses are ready.
Presentations were also made by attorneys general representing each of the 6 geopolitical zones. Our next item on the program is an assessment of Nigeria's justice sector under the Buhari presidency in the last 5 years. One thing President Muhammadu Buhari will be noted for is his signing of executive orders to further press home the need for the implementation of any particular policy. This is one of the areas we are delving into as we do a series of justice sector evaluation in the last 5 years. Our guest today is Dr. Hassan Liman, Senior Advocate of Nigeria.
We are lucky as a nation from independence when we had military interventions. From 1999 till now, we have an uninterrupted civilian administration. The present regime came into power 5 years ago. And as we know by our constitution, there are 3 arms of the government: the executive, the judiciary, and the legislatures. Though the Ministry of Justice is part and parcel of the executive, but when it comes to the issue of justice, though the judiciary is standing as an independent arm of government, when it comes to the issue of justice, but the executive, through the Ministry of Justice, that's the Office of the Attorney Generals of the Federation and the states, vis-a-vis the Nigerian judiciary, I will say that we have done a lot, and this administration has done so much in terms of justice reform and carrying the banner of administration of justice to greater height over and beyond what we used to have in the past.
Now, when you talk about the banner of justice, one of the areas that is fast emerging in Nigeria is the signing of executive orders by the president. Let's talk about the legal basis for it.
You see, the Nigerian Constitution gives the legislatures the power to enact law, and the president assents it and it becomes law. Laws, when made, are executed by the executive in furtherance or in the exercise of the executive powers of the president, in giving effect to the necessary intendment of the legislation. For instance, if you take the provisions relating to the fighting of corruption, you have the EFCC, in which the EFCC and the Establishment Act is there. You have the ICPC, in which the Independent Corrupt Practices Act is there. But they carry out their duties in accordance with the provision of the Act. Wherever there is some difficulties or lack of clarity, I must say with all sense of responsibility, and you need to carry out swift and rapid execution of those laws to give the necessary intendment of the provisions of the law to accelerate the due execution of that law. The President of the Federal Republic of Nigeria has the power to issue executive orders, and that is exactly what this President has done in the last few years and even the last few weeks.
Yes. Now, talking about the last few weeks, he just signed an executive order 10. Did we need an executive order in that area, particularly when the Constitution already so provides?
You see, the Constitution has provided that these arms of government, the legislatures and the judiciary, especially at the state level, I know as a fact that at the federal level, do implementation or do remittance of the entitlements of the legislatures and the judiciary is normally not meted in accordance with the provision of the Constitution. At the federal level, that problem is not there. Okay. So in ensuring the compliance and due implementation of the provision of the Constitution as regards the right or due entitlements of the legislatures at the state level and the judiciary at the state level, the President, what he has done under the executive order is to ensure the due enforcement of that provision of the law. By his oath of office, he has sworn to ensure the due compliance with the provisions of the Constitution of the Federal Republic of Nigeria. What he has done, he has not done anything outside the law, but to ensure that there is due compliance. So by giving directive to the Accountant General of the Federation and the Minister of Finance, is just to ensure that those provisions of the Constitution are met. But we have a problem whereby, with the greatest respect, state governors, after these monies are remitted to them, they are just expected to remit it directly to the accounts of the state legislatures and the judiciary. But most of the states, despite the provision of the Constitution, despite the decision of a court of law, still sit on the remittance or the budgetary remittance of the judiciary and the legislatures. So what the President has done it within the ambit of the Constitution.
Let's look at justice dispensation generally. Has it been swift enough, in your opinion?
Justice dispensation, if we compare what has happened in the past and what we have in the present, I will say it has been swift.
The idea behind examining past performance is to help project into the future. We shall continue this assessment in the coming weeks. Thanks for availing us your time this week. We shall see you again.